Welcome. I am Al Frioni, the Commissioner and Chairman of the Workers' Compensation Appeal Board. Today's training will orient you to the new screens, processes, and correspondences which will be updated in WCAIS on July 11th, 2022. These WCAIS changes will correspond to the recent amendments to the Pennsylvania Code that modify the appeal process and will substantially change the practice of law before the board. We are very excited for these changes as they are the most substantial regulatory changes to the appeal board in 50 years. Thank you for your attentiveness to this training session as it will allow you to be best prepared for this upcoming release. I will now turn the presentation over to the WCAIS training team.
Thank you. Now we will cover the agenda for today's session. First, I will provide an overview of the hot bench and virtual hearing release. We will then do a deep dive on the WCAIS screens and correspondences which will be impacted by the release. These include the appeal acknowledgement letter, submitting petitioner and respondent briefs, filing a brief extension request, supplemental briefs, continuance, venue change requests, and the entry of appearance impacts to briefs. To conclude, we will review important reminders and next steps. Please note, some additional slides have been provided in the training materials distributed via email, which will not be covered during the session. Those slides will give you additional information about some small layout and field name adjustments which have been made to WCAIS, but which will not significantly impact your use of the system. Up first is the hot bench and virtual hearing overview. This release was initiated due to regulatory changes to workers' compensation appealed board law. The first impact was to permit electronic or virtual hearings to be conducted starting in December of 2021. The second impact, and the one which most of this training session will discuss, is that the rules of the practice and procedure will be modified to a hot bench. The two areas of greatest impact to attorneys are to the submitting of petitioner and respondent briefs and the filing of brief extension requests. Overall, 24 screens or documents have been affected, and some new screens and correspondences are being introduced. As of July 11th, 2022, all appeals which are filed will be governed by these new regulations. Appeals filed prior to July 11th will be governed by the old regulations. Subsequent appeals and cross appeals filed to those under the old regulations will also be governed under the old regulations. Most of the processes we will discuss today are for screens impacted by the new regulations. Now we will do a deep dive on the updates to the WCAIS screens and correspondences.
First, we will discuss the updates to the appeal acknowledgement letter. One change that will be seen across all WCAB screens under the new regulations is that currently, the individual submitting the appeal is labeled as the appellant, and the other individual is called the appellee. In the new regulations, they will be called the petitioner and respondent. You can see this indicated on the new grid on the appeal acknowledgement letter. It includes which party is the petitioner or respondent, the brief due date, and the brief status. When the initial acknowledgement is sent, the petitioner's brief due date is 30 days from the board's acknowledgement of the receipt of the appeal. This is a change from the current process where the brief may be submitted on or prior to the date of hearing. The respondent's due date will be updated after the petitioner's brief status is no longer pending. Last, this letter contains two important notes. First, that the brief due date will be enforced. If the brief due date is missed and the attorney fails to request a brief extension prior to the due date, there will be no additional opportunity to submit the brief. Second, this indicates that a hearing preference will be required when submitting a brief. We will look at how to select a hearing preference in the next section. In this section, we will cover the new process to submit briefs, including the brief and proof of service correspondence, the new respondent brief due date notice, and the new briefing period closure notice. This slide provides an overview of the updates made to the brief filing process. The petitioner's brief will no longer be due on or prior to the date of argument. Now, the petitioner's brief will be due within 30 days of the board's acknowledgement of receipt of the appeal. The respondent's brief will now be due prior to the date of argument. In fact, the hearing won't be scheduled until the respondent's brief period has ended. The respondent will have 30 days to submit a brief once the petitioner's brief status is no longer pending. So, once the petitioner either submits a brief, notifies the board that no brief will be submitted, or misses the brief due date, then the respondent's 30-day period for submitting the brief will be set. The next change is that a one-page summary of the argument must now be submitted with the brief. Last, parties will now choose a hearing preference, either in person, electronic virtual, or waive hearing. Let's take a look at the updated timeline for how and when briefs will be submitted. After the appeal is filed, the board will issue an acknowledgement letter along with the petitioner's brief schedule. Next, the petitioner will be responsible for filing a brief within 30 days of the appeal acknowledgement. As noted on the previous slide, the submission of the brief will now also include submitting a summary of the argument and selecting a hearing preference. Once the petitioner's brief status is no longer pending, the respondent's brief due date will be set to 30 days later. So, if the petitioner submits the brief 10 days into their 30-day period, the respondent's 30-day period will start immediately after the brief is submitted. Once the respondent has submitted the brief, the appeal board will schedule the hearing. The commissioner will be able to review all briefs prior to the hearing, and the hearing will usually be in the form requested by the parties when they selected a hearing preference. However, the board is able to override the preference by selected by the parties if needed. So selecting a hearing preference is not a guarantee that you will have a hearing in the form you request. For example, in disfigurement cases, the hearing will always be in person. Now, we will show a demonstration of the new brief filing process. This process is the same for the petitioner and for the respondent. This process begins on the Briefs tab of the Appeal Case Summary. First, select the radio button for the brief you wish to submit in the brief schedule grid. Then, select Submit Brief from the Action drop-down menu, and then press the Continue button. 3 steps are needed in order to file a brief. The brief must be submitted, a one-page summary of the argument must be submitted, and a hearing preference must be selected. To submit the brief, first, ensure that document type of brief is selected, and then press the Choose File button. Select the brief document, and then press Open. If needed, enter a document description into the Document Description field, and then press the Upload Document button. Next, in order to submit the summary of the argument, 2 options are available. The summary of the argument may be uploaded using the Upload Document section, selecting Summary of the Argument as the document type, and then choosing and uploading the appropriate file. Alternately, you may type or copy and paste the summary of the argument into the Summary of the Argument field. Last, the hearing preference must be selected from the Hearing Preference drop-down menu. Then, press the Continue button. For each party, select the applicable manner of service from the drop-down menu in the Manner of Service column. Any changes to the parties can be noted in this field for WCAB staff to review. Next, check the Proof of Service checkbox and press the Submit button. By selecting the print link or pressing the print button, you may print this confirmation screen for your records. In addition, by pressing the Here link, you can navigate to your dashboard and print the proof of service. Now, we'll continue with additional possible steps related to briefs and related correspondences. The columns of the brief schedule grid will be updated. For brief schedules on appeals governed by the new regulations, the columns will be updated as it displays in the top section of this slide. The appeal number column will display. The brief status will display along with the date of the status change, and the hearing preference column will display. The brief schedule grid for appeals governed by the old regulations will have a layout as seen in the bottom screenshot. Please note, no hearing preference column displays for old regulation briefs. If the party chooses to not submit a brief, not being submitted should continue to be selected from the Action drop-down menu. This will allow the brief submission period to close and the next step of the process, either the submission of the respondent brief or the scheduling of the hearing, to begin. Now, there's an additional step to complete when selecting Not Being Submitted. The Hearing Preference drop-down menu will display once Not Being Submitted is selected. The party must choose a preference before pressing to continue to submit the response. The Brief and Proof of Service Correspondence, which was previously named Proof of Service for Brief, will now be a single document which includes the summary of the argument if it is uploaded rather than typed, the brief, any other documents uploaded by the filer, and the proof of service page. This slide displays the brief and proof of service correspondence. This first page displays the new grid with the petitioner and respondent's brief due date and brief status. The summary of the argument will display in the section below the grid if it is typed by the filer. If it is uploaded, the summary of the argument will be merged into the document and this section will be empty. Additionally, the hearing preference selected by the filer will display at the bottom. The proof of service section will display on a separate page. The parties will display in a grid format as seen on the slide. This new correspondence will provide the respondent's brief due date. Remember, the respondent's due date will be set to 30 days after the petitioner's brief is no longer pending. For the example in this slide, the petitioner's due date was April 20th, but the brief was submitted on April 13th. That means that the respondent's due date will be May 13th, because that is 30 days after the petitioner's brief was submitted. The information in this correspondence will also display on the Briefs tab of the Appeal Case Summary. As a reminder, briefs will not be accepted after the brief due date, so it's very important to submit on or prior to the due date. After receiving the respondent's brief due date, the respondent may submit their brief. This process is the same as submitting the petitioner's brief. This new correspondence will be distributed when both the petitioner and respondent have either filed their briefs, elected not to submit a brief, or their due date has passed. The briefing period closure notice indicates information about the hearing. The information provided in the paragraph will vary depending on whether the hearing is in person, electronic, or waived. In this section, we'll discuss brief extension requests. WCAIS has a new restriction for requesting a brief extension. The request must be submitted before the brief due date. If the brief extension request is submitted on the brief due date, it will not be accepted. Looking at the example on the screen, the filer is attempting to submit the extension on May 13th, the same day as the brief due date. Therefore, WCAIS is displaying an error message and the filer is not able to submit the request. On the Submit Brief Extension Request screen, the number of days for the extension request will default to 30 days for the first request. The requester will not be able to change this field on the first request. The reason for the request is still required. It may either be typed into the text field or it may be uploaded as a document. The Attached Documents section now displays when first entering the screen. Previously, it didn't display until after the position of each party was selected. If the position of a party is unknown, the number of attempted contacts field is now required before pressing Continue. To view the details of the brief extension request, you can navigate to the Request tab of the appeal case and select the Brief Extension Request link. Now, we'll discuss an update to Supplemental Briefs. Supplemental briefs will not always be permitted. If the board has authorized supplemental briefs to be submitted for a case, a checkbox will display on the Briefs tab of the appeal indicating that supplemental briefs may be submitted. If you attempt to submit a supplemental brief and this checkbox is not displayed on the Briefs tab, an error message will display with instructions to contact the appeal board for assistance. This next enhancement is to the Continuance venue change request. A venue change can now be requested in the same manner as requesting a continuance. This request will display on the Request Type drop-down menu on the Request tab as Continuance/Venue Change Request. A venue change should be requested if you need to move from an in-person to a virtual hearing, or vice versa, if you would like to change to a different in-person hearing location, or if all parties are waiving the hearing. On the Complete Request tab of the Submit Request screen, you will need to indicate your reason for the request either by entering it into the text field or uploading a change request document. Staff will review the request and make the change if it is approved. The updated response letter will indicate whether the request is granted or denied. If it is granted, original and new hearing information will display. If the request is denied, the original hearing information will display as a reminder. The next few slides will provide information on what will happen to the brief schedule if an entry of appearance is submitted. Currently, when one attorney or pro se party replaces another one on an appeal with a brief schedule, the initial attorney's name is replaced with the new attorney's name. There was no longer a record of the initial attorney's brief schedule. Now, the initial attorney will remain on the brief schedule, but with the brief status of no longer required. Looking at the example, prior to the entry of appearance, defendant's attorney number 1 displays on the brief schedule with a pending brief. This screen shows the impact after the entry of appearance. Defendant's attorney number 1 continues to display on the brief schedule, but with an updated status of no longer required and the date of the entry of appearance. Defendant's attorney number 2 is added to the brief schedule and will have the same brief due date as the party that was replaced. Please note, no updates will be made to the brief schedule unless the brief status of the party being replaced is pending. Now, we will cover next steps.
The PowerPoint presentation we reviewed during this session was distributed via email and includes additional reference slides. Please review the presentation when your schedule permits. As a reminder, these changes are scheduled to be implemented in WCAIS on Monday, July 11th, 2022. Training resources will be available in WCAIS online help once the release is implemented. An additional resource is available for your reference. If you wish to learn more about the overall changes to the Appeal Board regulations and processes, a presentation by Commissioner and Chairman of the Appeal Board, Al Frioni, is available on the link on this slide. Should you have any questions following the presentation, please contact the Appeal Board for clarification.